Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On January 19th, the court heard arguments in Federal Election Commission versus Ted Cruz for Senate, a case which concerned whether appellees had standing to challenge a specific feature of the statutory loan repayment limit, and whether that loan repayment limit violates the free speech clause of the First Amendment. Joining today to discuss this case is Professor Bradley Smith, the Josiah H. Blackmore and Shirley M. Nault Professor of Law at Capital University Law School. He is one of the nation's leading authorities on election law and campaign finance, having served himself on the FEC for 5 years, including as the chairman of the commission in 2004.
Back in January of 1976, the Supreme Court decided Buckley v. Vallejo. In that case, the court held that major portions of the Federal Election Campaign Act, or FEC, were unconstitutional, but it also upheld major portions of the act. Commenting on the court's decision back in 1976, the Wall Street Journal editorialized that the law will probably act like the Frankenstein's monster it truly is. It will be awfully hard to kill, and the more you wound it, the more havoc it will create. The problem with the Federal Election Campaign Act, frankly, is that it regulates discussion about candidates, elections, and public affairs, precisely the speech that the First Amendment intended to protect. This is a tough circle to square, and as a result, the Supreme Court has spent literally decades now embroiled in campaign finance disputes. Many of these cases, including Federal Election Commission versus Cruz, or as I'll call it simply FEC v. Cruz or Cruz, arise under the High Court's appellate docket, so even if the court wanted to, it can't dodge those cases by denying cert. Now, Cruz itself deals with a relatively arcane provision of the 2002 Bipartisan Campaign Reform Act. This was a set of major amendments to the Federal Election Campaign Act. It was better known to old-timers who will remember it as McCain-Feingold after its primary U.S. Senate sponsors. The substantive question presented is as follows. When a candidate for federal office lends money to his own election campaign, federal law imposes a $250,000 limit on the amount of post-election contributions that the campaign may use to repay the debt owed to the candidate. And then the substantive question is whether the loan repayment limit violates the free speech clause of the First Amendment. We should also know that there is a second procedural question, a standing question, whether appellees have standing to challenge the statutory loan repayment limit. The provision itself was part of something called the Millionaires Amendment to BICRA, the Bipartisan Campaign Reform Act, and some background on that amendment is probably in order. Under FECA, contributions to candidates are capped at $2,900. This amount is adjusted periodically for inflation, but that's the current limit. This limit tends to benefit incumbents in fundraising in three primary ways. First, incumbents know typically that they are running much sooner than challengers, often the day after their last electoral win. Now, to raise the money one needs to campaign in chunks of no more than $2,900 per contributor takes a long time. And challengers often don't get into the race until much later, sometimes not until the election year itself, so they have less time to raise that money and have to concentrate more time on fundraising and may not raise as much. Also, incumbents tend to have, in most cases, higher name recognition than challengers when the race begins, and that makes fundraising easier. And moreover, they have a database of past donors to their campaign, so they have the ability to go to people who are familiar with them, have supported them in the past, and that's a great way to start your fundraising. These advantages can be at least partially offset, however, by a self-funded candidate, that is, a wealthy individual who will contribute his or her own money to the campaign. The law allows that. Actually, I should say that the Buckley decision allows that on the grounds that a candidate can't corrupt himself. So candidates can contribute as much as they want or loan as much as they want to their own campaigns. Now, and that helps a challenger overcome these incumbent fundraising advantages. Now, being human, incumbent politicians tend to think of the advantages that they possess as being natural and appropriate and fair, but any advantages that are held by their opponents are suspect and unfair. And at about the time of the McCain-Feingold law, there were more and more episodes of these wealthy candidates self-funding their campaign, and this became almost a threat in which Congress was almost paranoid of the idea of having to face a self-funded challenger, because that would erode much of their fundraising advantage. So BICRA included what was called a Millionaire's Amendment, and this had two parts. First, when a candidate was facing a self-funded opponent, a person who spent over a certain amount on their own campaign, then the contribution limits for giving to the opponent of the self-funded candidate, but not to the self-funded candidate, only to his opponent, were trebled. So instead of today $2,900, you could give almost $9,000 to the campaign. Secondly, they limited loan repayment to $250,000 with any funds raised after the election, making candidates less likely to loan money to their campaigns. So you might loan a large sum to your campaign. If you figured there was a 40 or 50% chance of getting it back, maybe higher, you'd be less likely to do so if you thought that there was no chance of getting repaid. And so this effectively tended to dampen enthusiasm for candidates to loan money to their own campaigns. Now, pursuant to Buckley and its numerous progeny, limits on campaign contributions and spending curtail First Amendment rights by limiting the ability of candidates and others to speak about politics and to associate to pursue political goals. These infringements on the First Amendment can only be justified by a compelling government interest, and the compelling government interest here that the court used in Buckley and since is the interest in preventing corruption or its appearance. But the Millionaire's Amendment was never about preventing corruption. The primary sponsor of the loan repayment provision, Senator Hutchinson, said in the floor debate that the amendment's purpose was, quote, to level the playing field, by which he meant to benefit incumbents. Then Senator Harry Reid specifically called the provision, quote, an incumbent advantage measure in the underlying bill. And then Senator Daschle specifically said, this is all on the floor debate in the Senate, this measure, quote, protects incumbents. This was widely known and understood at the time in the Senate. And in fact, the entire Millionaire's Amendment doesn't even make sense as an anti-corruption measure. If you want to prevent corruption and think that contributions to a campaign are corrupting, you would not treble the contribution limits for an incumbent or any candidate who's facing a well-financed challenger, and when that person, the opponent of that challenger, really needs money. Data also shows that the amendment has, in fact, had the effect of limiting candidate loans, that candidates tend not to lend now more than about $250,000 to their campaigns. Now, we might think that that's a lot of money. It is for the vast majority of people, but recognize that what this really does is it, in some respects, helps extremely wealthy candidates at the benefit of kind of wealthy candidates. In other words, a candidate who can lend the campaign $500,000 or $1 million, but with some prospect of getting paid back, may do it, but that candidate may feel like they can't just absolutely write off the entire amount, whereas an extremely wealthy candidate can do so. And anyway, the facts of this case are as follows. In 2018, Senator Ted Cruz found himself in a very tough match with Beto O'Rourke, and he would eventually be outspent by over $30 million. The race was ultimately the closest U.S. Senate race in Texas in 40 years. And shortly before the election, Cruz loaned his campaign $260,000. But the provisions of the Millionaire's Amendment prevent him from repaying more than $250,000 with funds raised after the election. I should point out here, by the way, that campaigns have long used post-election funds to pay off campaign debts. And we should also note that after Election Day, Cruz's campaign had enough in funds raised before Election Day to repay him, but instead used that money for other debts. Cruz then sought to repay his loans with funds raised after the election, which was prohibited by the statute. In other words, frankly, it's quite true that Senator Cruz managed his affairs here, at least in part, in order to set up circumstances to challenge the loan repayment bar of the Millionaires' Amendment. He wanted to challenge that provision, which he thought was unconstitutional. Now, given the fact that the Millionaires' Amendment doesn't really have any anti-corruption rationale, and such rationale is belied by the statements of its sponsors in Congress. And given Senator Cruz's intention to challenge the provision in court, it's not surprising that at oral argument, Deputy Solicitor General Malcolm Stewart, who was assigned the case, and I should point out that Malcolm Stewart is probably the most experienced career lawyer in the Solicitor General's office when it comes to campaign finance. He's argued many cases, including more than one in the Supreme Court, going back over 30 years. In any case, Stewart focused much of his argument on standing. He argued that any injury suffered by Cruz was self-inflicted, and therefore the case should be dismissed as not meeting standing requirements. I will say that there is very little sign that the court would go in that direction, and Justice Thomas went so far during oral argument as to suggest that Stewart's theory would have denied standing to Homer Plessy v. Ferguson, since Plessy's decision to sit in a whites-only rail car in order to challenge a law mandating segregation could similarly be considered a self-inflicted injury. Prior to the argument, there was some hope among campaign finance regulatory advocates that maybe the court would choose to rule on standing, and we should note that at argument, Chief Justice Roberts showed some interest in other possibilities of finding a procedural out, suggesting maybe the statute providing for direct appeal to the Supreme Court did not apply here, which got Justice Breyer to hop in with tremendous support. But frankly, I don't see that happening. I don't see any of the other conservative justices showing interest in taking that route. On substance, the government's argument was that after an election, donors know that the candidate has won and will be an office holder, and then can anticipate that by donating, the elected office holder will benefit personally. That is, he won't have to write off the loan, which otherwise he would have to do. Therefore, the repayment is actually more like a gift. Of course, that's an odd definition of a loan to suggest that a lender is personally enriched in a corrupt fashion when loans are paid back. And as Justice Alito later pointed out in questioning Cruz's lawyer, the very able Charles Cooper, the law applies even to candidates who are not elected to office. They also cannot pay themselves back, although there's no corruption possibilities there. In any case, given the clear intent of the Millionaires' Amendment to level the playing field and to benefit incumbents, I think that kind of argument that the loan is actually a gift is really something of a stretch. Further, Justice Kavanaugh zeroed in on the logical weakness of Stewart's argument. Assuming that the government's description of a loan as a gift were true, then why allow repayment of up to $250,000? Doesn't that equally, so to speak, go directly into the lawmakers' pockets? Justice Kavanaugh also noted that the loan repayment provision would prevent challengers from spending personal money late in a race because the campaign would not have pre-race funds from which to repay it. And Justice Barrett piled on, noting that there is no evidence of actual corruption from any loan repayments in any case. These two observations, I would note, were the focus of our brief, the amicus brief filed by my organization, the Institute for Free Speech. We noted in particular that public opinion polls showing voters held Congress in low regard simply cannot substitute for actual evidence of corruption, and further that to the extent public confidence in Congress is a legitimate goal, it has not been correlated with campaign finance in any way. Yes, Congress thinks very little or people think very little of Congress, but it's not because of campaign finance laws. We also noted that by focusing narrowly on the loan repayment, the government overlooked the fact that the candidate is ultimately no better off for financially loaning money to his campaign committee. In fact, it's very likely he'll end up worse off because he won't be able to repay himself or won't be able to raise the funds to do it or is out the time value of the money, and that by discouraging loans, the provision limits the reach of the campaign committee's speech. Just counting the votes, Justices Gorsuch, Alito, and Thomas showed no signs of moving off their traditional skepticism of campaign finance laws, while Justice Kavanaugh and to a lesser extent Justice Barrett were among the most aggressive questioners of the government. As noted, Chief Justice Roberts showed some interest in procedural remand, but none at all in the government's substantive position, and it should be noted that on these First Amendment cases, he truly has been a rock in support of the First Amendment. Indeed, since the advent of the Roberts Court in 2006, supporters of campaign finance regulation have clearly been on the defensive. In FEC versus Wisconsin Right to Life, decided in 2007, the court held that a ban on corporate ads discussing public issues close to an election was unconstitutional as applied. The next year in Davis v. FEC, the court struck down that other portion of the Millionaire's Amendment, those differential contribution limits. In 2010 came the blockbuster Citizens United, where the court struck down a prohibition on corporate advocacy of the election or defeat of a candidate for office. In 2011, in Arizona Free Enterprise Club versus Bennett, the court struck down provisions of Arizona's government financing law dealing a serious setback to government-funded campaigns. And in 2014, the decision in McCutcheon v. FEC, the court held that aggregate caps on giving, i.e., limiting how much an individual could give not just to a particular campaign but to all candidates combined, were also unconstitutional since they serve no anti-corruption purpose. So ultimately, can this Frankenstein's monster be put down? Well, if FEC v. Cruz won't be enough to do the job, but the monster is clearly in retreat, and I think at the end of the day, the court is quite likely to push it back just a little bit further with this decision.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.